Hi, I'm New Mexico attorney Nadia Cabrera Mazio, and in this video, we're talking about when handshake agreements are legally enforceable. The thing is that handshake agreements generally are legally enforceable, but regardless of that, it is really hard to prove them because there's no evidence, there's no documentation or video evidence that the person agreed to be bound by the terms of the agreement that they made, that they intended for their promise to be legally binding. And when I say legally binding, I mean that you have legal resources available to you to enforce that promise, to either make the person do what they promised that they were going to do, or pay you money or give you some other alternative to make up for the fact that they are going back on their word. A handshake agreement is not legally binding in several circumstances where a writing is required. For our purposes in this video, the three main circumstances are that it's for a sale of goods worth more than $500, if the contract cannot be completed within a year, or for the sale of real estate. So if you're selling land, in order for a promise or a contract to be legally enforceable, it has to be in writing. If it's a lease for more than a year, it has to be in writing if you want to be able to enforce that. It is always best to have some kind of writing or some kind of evidence to show that you intended for those promises to be binding. A contract doesn't have to be an incredibly difficult and complicated thing. It can be as simple as writing something down on a cocktail napkin. There's an infamous case in the legal world called Lucy v. Zamer, where a farmer at a bar jokingly offered to sell his farm to a man who had been really wanting that farm for several years, but the farmer always said no. For the farmer, it was a joke, but he still wrote down on the napkin that he would sell his farm to this person for a certain amount at a certain time. Even though for the farmer it was a joke, nobody else really knew that. There was no outward manifestation that he didn't intend to be bound by his promise, and so a court eventually did force him to sell his land to the person, and the farmer was very upset about it. But it does teach us about the power of contracting, that even something as simple as a scribble on a cocktail napkin can be strong enough to meet all of the contract elements and to make a promise binding. The other major lesson from that case is that the outward manifestation that you put out into the world, whatever you're communicating out into the world, trumps any unexpressed internal feeling. Also keep in mind that enforcement actions don't always have to go to court. The fact that you have that written contract gives it that legal enforceability. It gives it those legal teeth that you want in order for someone to keep their word. So to recap, handshake agreements generally are legally binding, but they are hard to prove in any case. And in several circumstances, especially with the sale of real estate, sale of goods over $500, and if the contract will take longer than a year to perform, a handshake agreement is not enough. It is not legally binding. You need to have that in writing. And remember that the writing can be as simple as you jotting the terms of the agreement down on a piece of paper.